Hello, I'm G. Raleigh Hetherington of the Hetherington Law Firm. Today I want to talk about Texas inheritance and the fact that no will exists at the time when a person passes away. Let me say first of all that this is a cumbersome process that typically involves quite a bit of additional effort on the part of the surviving members of family and persons that may be entitled to assets of a person who passes away. So I encourage everyone in Texas to have a valid will prepared, executed during their lifetime, and you can refer to the other videos on this particular website with respect to Texas will and the probate of Texas will. But let's talk about inheritance. Inheritance simply means there's no will, and the state of Texas in the Texas Estates Code has set up who gets what of the assets of a person who passes away at that time. That's set out in the Texas Estates Code. I've also had the law firm provide a chart which sets out who gets what in the family upon the death of an individual if there is no will. And I refer to you to the news section where that chart is located. But let's talk about what property gets divided. In Texas, we are a community property law state, which simply means upon a marriage, everything that is acquired by way of asset after individuals marry become the community estate of the two persons who are married, and is split 50-50. And it's presumed once you get married that anything you acquire after marriage is community property. So what's separate property? Well, separate property of a person is anything owned by that person before they get married, or that they acquire during marriage by gift, or by inheritance themselves, or by a will. So why is that important? You will see on the chart that depending upon what type of property, whether it be community property or separate property, there are different percentages of distribution to family members, be it the surviving spouse, be it children of the person who passed away, as far as whether or not it's community or separate property. So, what do you do once you reach the point where we have to determine who gets what and whether it's community or separate? Well, you file what is called an application to determine heirship. In that document, which is filed with a probate court, the probate court makes a judicial determination as to who the heirs are and in what percentages they receive the property of the person who passed away. All right, probate court. There are probate courts in all 254 counties in the state of Texas. Those courts basically handle the probate of wills, but they also handle the determination of heirship that I just discussed. So when you file the application for heirship, it must be done electronically through the probate clerk of that particular county. The county where that document will be filed is the county typically where the person resided who passed away, and that application must set out every single heir and their percentage of what they get under the terms of the statute of descent and distribution with the state of Texas. Now, once that's filed, the court will set a hearing. At that hearing, the person that has filed the application needs to bring with him two independent witnesses that don't receive anything under any circumstances that can talk about the family history and the heirs of that particular person. The court will also appoint what's called an attorney ad litem, which is an officer of the court appointed solely in the discretion of the probate judge, whose job it is to confirm that yes, these are the heirs of the person who passed away. So as you can see, there's quite a bit of time and effort and expense when you have to go through that application. You will also typically seek an administrator to be appointed by the court once the heirs have been determined, to administer any assets and to ultimately distribute assets after the payment of debts to the person who are entitled to it under heirship. So, as I indicated, this is a very cumbersome process. The state of Texas has also come up with what is called a small estate affidavit. Now, that is a much more streamlined procedure by which you can set out this type of information in one written document. You can have it signed by all the people who are entitled to the property as heirs and two independent witnesses. But this is a very limited ability. First of all, you can only have $75,000 of assets exclusive of your homestead and exempt personal property that can be transferred. You cannot transfer title to real estate under that particular procedure except your homestead. So it is a procedure that is available, and the firm would be more than happy to send you that information if you think that the estate would qualify for a small estate handling situation. So we look forward to visiting with you and providing this information to you so that we can assist in this heirship determination as well as distribution to the appropriate folks that are to get the properties under Texas law.